Good morning, and thank you for being here. It's been a while. I've had a little withdrawal of not being present, so I'm glad you're here. We're here today to announce that the Florida Education Association and one of our members, Tom Fossey, of East Lee County High School of Lehigh Acres, have filed a lawsuit over a bill passed on the last day of the legislative session in May. That bill, SB 850, contained a lot of unrelated items tied together only loosely because they related to education. SB 850 started out before the session as a modest bill that expanded Florida's high school program. As it was heard in various committees, the bill grew to include provisions on public school improvement and accountability, dropout prevention, school hazing, and middle school grades. On the last day of the session, two provisions that had failed previously, one that created personal learning accounts for students with disabilities, and the other expanding the corporate voucher program, were added to SB 850 in a 141-page amendment. That was adopted even though many of those provisions had failed previously. That's not right, and in a minute, Attorney Ron Meyer will explain why we believe that violates the Constitution. This was a sneaky way for the legislative leaders to enact measures that had already failed. It's an outrage that corporate voucher expansion was tacked on to an unrelated bill and slipped into law on the session's final day. These voucher schools have little regulation. They don't have to follow the state's academic standards. They don't have to hire qualified teachers, and they don't have to prove that the state's money is being used wisely. There's no link between vouchers. There's no link between voucher schools and the gains in student achievement. Yet the legislature and the governor continue to forge this path. It is time that we hold them accountable, that we make our voices heard, and it is time that we take back our schools, our state, and our future. And this will be the first step of many as we forge that path. And now I'd like to introduce to you Tom Fossey. Tom? Make it harder.
Thank you, Joanne. I'm Tom Fossey, and I'm a social studies teacher at East Lee County High School in Lehigh Acres. I've taught U.S. government and U.S. history to both regular and advanced placement classes. One of the things I discuss with my students is how a bill becomes a law. I talk about the process, how a measure is formulated, how it's heard in a public forum through the committee process, how it's debated and voted on. In our democracy, the legislative process is supposed to be open and transparent, and there are rules to follow as a bill makes its way through the legislature. I'll certainly be using SB 850 in the future as an example of how this open and transparent process can be hijacked. SB 850 was heard in committee and approved and moved on for passage by both the Florida House and the Florida Senate. But in the final hours of the last legislative session, two measures that had failed to pass the previous day were tacked onto the bill without proper hearing. It was a backdoor method to resurrect previously failed legislation. Is this any way to pass laws? The people of Florida should expect that laws are clearly expressed and properly vetted, and that laws that fail to pass shouldn't be tacked onto unrelated legislation at the 11th hour. I'll be using the story of SB 850 in future classes as an example of what not to do to pass a law. I sincerely hope that this lawsuit will provide our courts, the third branch of government, with an opportunity to teach the legislature and the governor that there's a right way and a wrong way to pass legislation.
Good morning, I'm Ron Meyer. With me here today is Jennifer Bloom, my law partner, and Pam Cooper, the General Counsel of the Florida Education Association, part of the legal team that's initiated this lawsuit. We filed the suit this morning in the Leon County Circuit Court. It's a fairly straightforward challenge to the way, the manner in which Senate Bill 850 was enacted. The term log rolling is often used when you lump together a bunch of unrelated measures into a single piece of legislation with the idea that some people will like one piece of legislation, others will like one different piece, and collectively they may pass a bill without it being thoroughly considered. But Article 3, Section 6 of the Florida Constitution provides, and I quote, Every law shall embrace but one subject and matter properly connected therewith, and that subject shall be briefly expressed in the title. What this lawsuit alleges is Senate Bill 850, and particularly the last-minute 141-page amendment, which was surfaced in the last day of the legislative session, violates that constitutional requirement. It's log rolling as a poster child here. It's what's wrong with a process, and somebody had to stand up and say enough, and that somebody is Tom Fossey and the Florida Education Association. We'll be happy to entertain any questions that you might have. Jerry?
So by challenging it under single subject and the way that you crafted this lawsuit and going after the bill itself, did you all give any thought to whether or not there remains a legitimate legal challenge to the underlying programs due to the Bush v. Holmes ruling or the first DCA ruling? And if so, why did you choose to go this route as opposed to that other route?
Well, we chose to file this lawsuit at this time because we think the manner in which this expansion of the voucher program was enacted is simply wrong. And somebody needs to stop and take a minute and say, what you did is wrong. You know, it's interesting that even the House final analysis, the bill analysis for the House version of this bill, 7033, points out in multiple places where these different provisions are not germane, are not reasonably connected to one another or to the main purpose of the bill. This is a procedural attack that we've made to the way in which this law was enacted. And we put aside for the moment the question of whether the underlying programs contained in this bill or expanded in this bill are unconstitutional.
As a quick follow-up, are you all making that as a conscious decision because you would perhaps come under criticism if you were attacking a program that helps low-income children or the McKay program which helps children with disabilities?
Well, there's nothing in this lawsuit or in this bill that deals with the McKay program, so let's put that aside. With respect to the underlying tax credit scholarship voucher program and its constitutional questions and possible infirmities, that's for a separate consideration for a separate day. All of the education stakeholders in Florida, the school boards, the parent groups, certainly the Florida Education Association and its members have grave concerns about the constitutionality of the tax credit program and the damage potentially that is being done to students in these unregulated, unaccountable schools. But this lawsuit isn't about that.
Are you hoping as well to get a judicial order that stops this? Because this program is rolling out right now.
What we're going to do, we believe that this case can be resolved on the basis of a motion for summary judgment because the facts are pretty well straightforward. There aren't facts in dispute. The bill was enacted in the manner in which it was enacted. The law says what it says. So we're going to move this case expeditiously toward the end that we can get a declaratory judgment finding that the way in which this bill was enacted is unconstitutional and therefore the bill is a nullity.
Can you speak a little bit to other cases where, you know, log rolling on legislation is sort of a legislative tradition in some respects? Have they been tripped up before when challenged?
There have been cases where disjoinder of issues occurs in legislation where different concepts that aren't reasonably related to one another are engrafted into a single piece of legislation, and the courts have found them to be improperly enacted and unconstitutional. We think this is a poster child for improper log rolling. The number of different unrelated concepts that are in Senate Bill 850 defy explanation, and the fact that some of these concepts failed on their own merits individually and are now just stuck in as an amendment to the main bill on the last day of the session without really any serious floor discussion or debate, just, we think, so vastly crosses the line that somebody needs to say, you can't do it. Log rolling's always happened, and I guess unless somebody says you have to follow the Constitution, people will continue to go forward not following the Constitution.
final version of the bill had a title simply education. Do you plan to argue that these are unrelated to education?
No, what the Constitution says is, again, shall be briefly expressed in the title, the subject matter. The title of this bill actually extends about 5 pages in the bill. It begins with an act relating to education, but if that's all that had to be said, all of the concepts in the loose sense relate to education. They don't relate to one another, however. And we feel that not only is the title infirm, the multiplicity of subjects contained in that legislation is inconsistent with the single subject requirement of the Constitution. And I'll also say, just, you know, the bill, for example, the corporate or the tax credit scholarship voucher expansion provision, the separate bill which failed the day before this amendment wasn't an act related to education. It was entitled an act relating to educational choice. So even the way they described it in the legislature, it wasn't just simply a bill relating to education. It was relating to choice. They knew what they were doing, and they went ahead anyway, just in their zeal to pass this.
Can I ask Ms. McCall, or the gentleman who filed the lawsuit, Mr. former Governor Bush's group has already put out a statement in which they are calling this a new low for the FEA, and that it's shameful that you would do this not because of the tax credit scholarship portion, but because the bill also included the personal student learning accounts. And they're saying basically what you're doing is you are denying opportunities to children with disabilities such as Down syndrome and autism, things of that nature. Could you address the fact that this lawsuit would in fact block the implementation of those personal student learning accounts?
Well, I would absolutely disagree with the former governor on that, in that regard, and he probably would say it's an all-time low because we are the only organization that is standing up and speaking out on behalf of public school children and all children. This is about making sure the Florida legislature and the governor do what is fair and just for all students in this state, not some, but all. It is their paramount duty, according to the Constitution, to fund public schools, and they are not doing that. And so we have to do what's right for all students in this state, and that is our stance, and that is how we'll move forward. There are always ways to do things in this state that are legal and just, and I believe what they did in 850 is not legal and not just, and I think it is our duty to stand up on behalf of all students.
Your organization supports Democrat Charlie Crist, and do you see that this kind of elevates this issue into the campaign, Crist versus Scott on corporate vouchers?
We do support Charlie Crist. We have come out in support of Charlie Crist, and we will work vehemently to have him elected as the next governor of this state. We believe he is the right choice for this state to move an agenda for pro-public education, and that is what we will do, and that is how we'll move. I said at the beginning of my opening comments, this is our first step of how to take back our schools, our state, our future, and Charlie Crist is one of those ways.
Having the lawsuit filed now, is that part of the motivation to get this into the campaign?
A part of this motivation to file this lawsuit now is we believe it is wrong, and we believe that we have a constitutional right to have this stopped before it's enacted. We looked at things in totality at the FEA, not as a single item, about moving the agenda for pro-public education, and those of us that work in our schools and those that serve the students of this state. This is about making sure that all the people in the state have a good future. It's about the state, about the people of this state.
Okay, the Vice President and Tom and Ron will be available if you want to have a couple of other questions. Thanks so much for coming out today.